Hi, everybody. Welcome to Inside the Practice, where we hope to be certainly your go-to podcast for expert-led discussions and actionable insights, things that you can actually use in the practice in the world of dentistry and its specialties. My name is Allan Hollander, and as always, my terrific co-host, Sarah Boylan. We have a terrific guest today, somebody we're very excited about. His name is Christopher Verbiest. I wouldn't be surprised if many of you have heard of Chris. Chris is a real expert with over 40 years experience in the insurance industry. Since 1998, he's been serving dentists around the United States. He has been a VP at very large institutions such as DBIC, Nordic, and TDIC, sought after speaker, regularly presenting at dental associations, conferences, study clubs throughout the United States. He's also lectured at the ADA annual meeting, dental schools in Oregon, Washington, Arizona, Tennessee. And any that I may have left out, Chris, feel free to fill in. Chris, great to have you here talking about risk management, a very, very relevant and important subject. And it's wonderful to have somebody who is a true expert in the area. So welcome to the show, Chris.
Thank you, Allan. It's an honor to be here. And thank you, Sarah, for the invitation. I do want to say, but before we get into the details of the program, that I am not an attorney. And so anything I say today is not construed as legal advice. The other thing is my primary experience, although not exclusively, has been in the Pacific Northwest. So if I talk about certain regulations of boards of dentistry, clearly they could be different than the state in which you're practicing. So before you absolutely take my advice, you might want to check with your board. With that said, I think we can get started.
Yeah, thank you so
Chris.
much.
Yeah, thank you for
so
that,
much
Chris.
For being here, Chris. I really appreciate seeing you. You and I go way back. I think the first time I met you was in 2004, and I was just a lonely little dental assistant, and I was in charge of charting all of the doctor's notes for him. And I took your defensive charting. Now, granted, the doctor at the end of the day would go back and make his own tweaks, but most assistants in practices do the chart notes and start the template, and then the doctor comes in and fills it. So I remember going to your defensive charting class and being new to dentistry, and I walked out of there really educated, darn near scared on all of the responsibility that I had now to make sure that I was charting everything correct. And over the years, I have had the pleasure of serving with you on other adventures through the Oregon Dental Executives Association and through some things with Moda Health. So thank you again for being here. And I guess I just really kind of want to lead into that charting with what is the most important thing a doctor can do to protect themselves from lawsuits from patients and mitigate HR disputes in the practice.
Well, it's always a pleasure, Sarah. We do go way back. It's been a great journey. As I get started, there's really three pillars to risk management. One would be communication. One would be documentation. And then, of course, informed consent as part of that documentation. It's an interesting class I sat through a number of years ago, and the presenter was a dentist from New Jersey, Dr. Mitch Gardner. And I would encourage anybody in the audience, if you have the opportunity to hear Mitch speak, he does an exceptional job. And I give him credit for this quote because I think it's so true. And he says, quote, "The biggest problem with patient communication is the misconception that it took place." And I think it's very true. And after years of looking over hundreds and hundreds of charts, employee handbooks, claims, I can tell you that it's true. The dentists have the best intentions, but even to this day still fall woefully short in their charting. And of course, the best defense a dentist can have is their chart.
Yeah. You've often said if it's not in the chart, it didn't happen.
Well, there's two things. If it's not in the chart, now you have, if you're at trial, you have a he said, she said. The patient is going to take one side and the dentist is going to take the other side. And by the way, you may have always had, as a dentist, a great relationship with the patient, but once there's a dispute, now that relationship's gone. There is no longer a patient-dentist relationship. Now it's about money. And that patient wants whatever pound of flesh out of you or your insurance company they can get. And so, interestingly enough, a jury will find a thorough and well-documented chart note to be the most credible evidence in a trial. So it's going to be more compelling to a jury than the patient testimony and the dentist testimony.
Right.
What dentists fail to understand, because they don't go through this process, most dentists don't get sued, is if there is a issue which might cause a lawsuit. And by the way, malpractice in dentistry is very rare. And we can get into standard of care and some of that a little later. But most claims made against dentists are not malpractice. But if a patient is dissatisfied and they file a claim, they hire a lawyer, the time in which you did the treatment that's in dispute and the time in which you go to trial might be 3.5, 4 years.
Oh, wow. That's a long time.
It is. And memories are short, especially considering the fact that over that 3 or 4 year time, you've probably treated 6, 7, 8,000 patients. And so, and you're going to be asked specific questions about that specific treatment on that specific date. And if you don't have it documented, it's going to be a very difficult conversation for you.
Fascinating. Chris, if I may, that's very, very interesting that most of these suits are not malpractice. What are they?
Well, it's a lot of them have to do with money. Mm-hmm. A lot of them have to do with circumstances that occur when a patient doesn't take the advice of the doctor. And a big thing is that the treatment doesn't meet the patient's expectations. Mm-hmm. And I'll give you an example. So if expectations aren't parallel, meaning the dentist and the patient have exactly the same expectations, there's going to be problems.
Right.
Patients don't listen very well. So let me give you an example of an actual claim. This is a number of years ago. A woman presented to the dentist. She was going to her 25th high school reunion. And she was recently divorced, and she wanted to look her very best. All right, don't we all, right? She went in to see this dentist. She had a picture of her favorite movie star smile, held up the picture and said, "This is the smile I want. And I only have $1,000 to pay for it." So the dentist calls me and he says, "Look, she wants a complete makeover. She wants $20,000 worth of work and she only wants to pay $1,000. And I said, "Don't do the treatment. She's not going to be happy. There's nothing you're going to say to her that's going to make her believe that anything less than what she wants is worth it. If you do the treatment, she's going to think in her mind that for her $1,000, she's going to walk out of there with a movie star smile." Did you listen to me? No. We did the treatment. The patient was very, very dissatisfied, hired a lawyer, went to court, filed a board of dentistry complaint. Now, in his defense, he did very good charting. So the case was thrown out immediately. So the lawsuit was tossed. But the board of dentistry said, "You should not have done the treatment." And this is in the state of Oregon. "You should not have done the treatment based on knowing that you couldn't fulfill her wishes. Therefore, you need to reimburse the $1,000 and give her an extra $1,500 so she can go get, additional treatment.
Wow. Wow.
And he could have walked away from this and said, I can't meet your desires. And we see this all the time. And I mean, if we had 3 hours, I could tell you example after example after example.
Well, and this is an example coming from how many years ago? I mean, today that could have been 10 times that. Those numbers could be 10,000 and 15,000 or even more.
Oh, easily. I mean, I had a very similar case where the patient spent $25,000. Mm-hmm. And the doctor was so upset, he refunded all 25, even though he did a beautiful job.
Oh my goodness.
So in a claim, when somebody files a lawsuit or a claim against a dentist, typically the insurance company will seek an expert in whatever that field was. Is it crown and bridge, endo, perio, whatever. And the expert will determine whether there's malpractice or there isn't. And I will tell you, between probably 85 and 95% of the time, there is no malpractice, meaning the standard of care was met. Might not have been a perfect result, but as Sarah, you've heard me say before, dentistry, like medicine, is an imperfect science. Mm-hmm. Bad things can happen in absence and negligence. And that happens all the time. Right. Most dentists, I find, are extremely wonderful people, very charitable, very nice, but they don't like confrontation. And when a patient confronts them with dissatisfaction, they write a lot of refund checks that really they shouldn't have to do.
Yeah. Well, I kind of want to move into that second part of the question too, as far as making sure that we're not only, practicing good charting for our doctors, but what about on the HR side of things? And what does that look like in your experience?
Well, interestingly, it's almost the exact same answer. It's documentation, documentation, documentation. Okay. So when I receive a call from a dentist, and here's typically how it goes. Chris, I want to fire this employee today. And I said, okay, pull out the employee file and let's review it together. Now, they call me for basic advice. If it really gets to the point where they're going through this, I always refer them on to an attorney. But, the dentists usually like to call me for this stuff because I'm the right price for it. But at any rate, so they'll go in their desk, they'll pull out the employee file. I said, well, what's in it? And I get this long, pregnant pause. Well,
what application?
File? Yeah, their application.
Oh, no.
I said, well, how long have you known you want to terminate this employee, and have you met with her to discuss what the problem is and some disciplinary actions? Oh, yeah. I said, well, where is it in the file? And guess what? It's not there. And just like documentation of dental treatment, if it's not there, it's presumed not done.
Right.
And if you go into court with an employee matter, first of all, the courts overwhelmingly, or the juries, I should say, side with the employees in these things, unless there's really perfect documentation. The jury is going to expect, the jury is going to expect that this is fully documented on what the employee's not doing right, what the correction procedures are, time frames, and then a time frame to rectify those things. And if it's not there, typically the employee will win the lawsuit. And by the way, they can be very, very expensive, especially if the claim by the employee is anything that's sexual in nature, sexual harassment. It can be hundreds of thousands of dollars.
Oh my goodness.
Yeah.
Chris, I have a question for you about this. And I don't know if this is a legal question, but perhaps you can comment on it. So let us say we went to this file and there were documents in the file, and somebody had been a little bit more conscientious and diligent about recording events or episodes with an employee. Does the document that's in there, does it have to be signed by the employee, or can it just simply be a record of the employer's record of the episode?
What we ask the dentist to do is to have the employee sign it or initial it.
Mm-hmm.
Sometimes they do, and sometimes they don't. They don't have to sign it for it to be valid.
I see.
So to answer your question, it just depends on the employee whether they're willing to sign off on that or not.
I got it. Okay, good. Thank you for that.
Yeah.
But-
So again, it kind of sounds like the communication, the expectations, having good policies and good job descriptions and things of that nature in place are helpful.
Yeah, so
Cool.
let's talk about what should be in a file. And I wrote these down, so forgive me for looking at notes, but there should be copies of any appropriate certificates or licensures for assistants and hygienists, an at-will agreement for employment, or the acknowledgement of an at-will agreement, the acknowledgement of receiving a handbook. So if doctors are not offering their staff handbooks, employee handbooks, there's plenty of resources for them. You need to have an employee handbook. An emergency contact for the employee.
Yeah, that's a good one.
References, if applicable, attendance records. A lot of these issues with termination is because of attendance records, and then the attendance records aren't in the file. Any compensation, workers' compensation incident reports, performance evaluations. At least in the Northwest, dentists have been pretty slack about doing annual performance evaluations.
Yeah, it's slack. It's slack everywhere, Chris.
And if you don't do a performance evaluation, and you don't have notes in terms of discipline or requests for job performance improvement, then you really have no case for termination.
Yeah. May I, Chris, a question as you're going through that list of on attendance records? Are you talking about a lot of offices have time clocks, so that would be a very easy way to document it. Could it just simply be a notation that an employee wasn't there or missed a day here? Just a notation on that. Would that be adequate?
Yeah. So what we see, Allan, is when these become issues, it's primarily hours they show up, hours they leave. And a notation in the file is excellent. But along with that notation in the file, a meeting with the employee needs to be required, because that meeting is now going to show that we brought this to the employee's attention.
Right.
And you might say something, I'll just make this up for an example, that if this behavior doesn't change in the next week or two or whatever, then there's going to be further discipline and potential dismissal.
Good. So you need to demonstrate that you have attempted to apply progressive discipline with the individual.
Absolutely.
Which is very, very important. Makes a lot of sense. And could you do this in an email? An email that seems it would be a valid documentation.
Well, you can, but the preferred way to discuss this or to communicate this with a employee is in person.
Okay.
And then, Chris, would it be important to have maybe an office manager available to be part of that conversation as well?
It's certainly advisable to have a witness, although not necessary.
Okay.
Yeah. Ideally, the doctor, let's say if it is the doctor, would have an office manager in the practice, which sadly some practices don't have. And it really would be the responsibility of the office manager to do this. But I like the idea of having a third party there to just observe and witness what was said.
Well, I can tell you what the attorneys, the employment attorneys that we either hired or counseled with in preparing for our classes said, yeah, it's okay to have the immediate supervisor do it, but in a small environment like the average dental office or the dental practice, it's better to have the dentist discuss disciplinary things with the employee. And like I said, it's perfectly acceptable to have a manager there as well.
Excellent. I know in my practice, that's how I handled stuff, was usually one-on-one. And then when it became escalated, I would bring the doctor in.
Yeah. And I think that's the wise way to do it, Sarah. One of the questions I always get from a dentist when I push back about terminating an employee with no documentation is they always say, well, isn't this an at-will state?
Yeah.
And of course, at-will means an employee or a employer can terminate employment at any time at their will. And I said, it is. But I said, at-will does not mean discrimination. And, oftentimes I'll say, who you want to terminate, how old are they? And it's usually a protected class of some nature that's over 40 years old, which is the cutoff for age discrimination. And I said, there are issues here where they could make a claim, true or not, it doesn't matter. They could make a claim for some sort of discrimination.
Yeah. And if you, and in these cases, unless you have actual evidence and documentation, you're going to lose. They're going to decide on the behalf of the protected class, which that's just going to happen.
The vast majority of time, at least in the Pacific Northwest, you will see an employer. It doesn't have to be a dentist. Any employer will lose an employment lawsuit if they don't have really good documentation. It's just kind of how those dominoes fall.
Yeah.
So what I'm hearing is document.
Well, I've been accused of saying the same thing over and over and over for 20 years of risk management, but it's true. I've been retired for a couple of years, and I went back to some of my fellow employees at the companies I've worked at that are involved in claims. And the same types of claims are true today that were true several years ago.
Interesting.
So that's a perfect jumping point, because that was another one of my questions that I had for you today, Chris, is what are the most common claims you see coming through these days?
So, let's go with common claims first, and then we'll go to more extensive type of claims. Okay. So the common claims are typical. They're crown and bridge, root canals, extractions, even simple extractions. Okay. And one of the problems with crown and bridge is the dentist doesn't have a stated warranty program with, let's just say, a bridge. Okay. Or crowns, it doesn't matter. Now, my understanding, correct me if I'm wrong, I've been out of it, but an insurance company will pay for crowns about every 7 years. Is that right? Do you recall? Okay. Yeah. So we had a patient sue a dentist because his I can't remember if it's crown or a bridge, but whatever the appliance was, broke after 23 years. And he filed a lawsuit, and an attorney took the lawsuit. Now, he won, but he had to go through all this rigmarole. So what I advise doctors to do is don't guarantee a crown or a bridge, because if you guarantee it, you're going to pay for those repairs for the rest of the patient's life. Have a warranty program. For example, if something happens to the appliance in the first 2 years, you'll replace it for free. If something happens in years 3 through 4, you'll give them a 50% discount, so forth and so on. So they understand this is how we treat all our patients. Okay, we're not going to do one-offs on this. We have a program here and a warranty program, and this is what it is. Now, the doctor can make it whatever he wants. I just gave that as an example.
Oh, that's a good.
Let me give you another case that we saw all the time. It was a patient presented for a cleaning and they needed an SRP. Okay. And the dentist explains, yes, it's going to take a little bit longer and it's going to cost a little more, but you have perio disease. And I highly recommend you have this done before further things can complicate the problem. And more often than not, the patient says, just clean my teeth. So here's what happens. If the dentist says, okay, and goes ahead and does a regular prophy, or the hygienist doesn't chart that they need an SRP, the patient walks out and says, oh, that dentist tried to upcharge me. I didn't really need that. And I got my teeth clean. And then what happens down the road? You have a perio claim.
Right.
Now, we've all been involved with dentists for a long number of years, and we know the vast, vast majority of dental treatment is voluntary. You can't force a patient to take the treatment plan that they need, but you certainly can chart in a manner that if they don't take the treatment and the condition worsens and they come back to you, where you can prove to a jury that you did everything you could. Let me find it for you because I want to read this off, and I hate to read during this, but I think it's a really important thing to talk about in terms of charting for an SRP. I don't know if I can find it. Bear with me for a second here. So a lawyer in Arizona, actually, a gentleman by the name of Jeff Tonner, who is a dental lawyer and also does risk management, came up with this charting note for patients that don't accept SRP. And I think it's perfect. Sarah, I'll remind you, if any of these you want me to post, I can send you these in writing and you can post them on the website later, okay? Because there's nothing worse than a presenter reading, but you'll get the gist here. So this is his perio chart. SRP recommended, but patient wanted only a prophy. Underneath it says patient needs an SRP, but only want a prophy because whatever the reason is. Insurance won't pay for it. I can't afford it. I don't think it's that bad. Whatever the patient says, okay? Told the patient that the prophy will have some benefit, but will not stop perio disease. Perio condition will continue to deteriorate with less than recommended treatment. Explain the risk of both tooth loss and possible serious medical conditions, cardiac, stroke, etc. Patient understands the risk but wants a prophy anyway.
Wow.
So if 2.5 years later, they start having whatever a serious complication of periodontitis is, and they sue that dentist, because they will. And what will they say? They'll say, I never knew I had this condition. I was never told.
Of course.
The dentist can say, well, here, I charted this 2.5 years ago.
And what I like about it is that it's got a specific reason. Like, why is it that they decided they want just a prophy and not, the full SRP?
Well, I can tell you, it all comes down to money. Money is the little underlying factor to almost all the reasons for malpractice.
Yeah.
So, it's funny because so many friends and actually family, my own mother said this to me some years ago. She said, boy, I went to the dentist today and they just want to upcharge me on everything. And I said, Mom, what you don't understand is a dentist has a legal obligation to do an examination and tell you the dentistry that they think you need, irrespective of cost, irrespective of time. This is what you need to do, and they're going to chart that. You have no obligation to accept that treatment. Because there have been malpractice lawsuits for failure to diagnose.
Yeah.
Right.
That's a great, that's a wonderful explanation for for a staff in a practice to understand and be able to communicate, or certainly for a treatment coordinator. I mean, look, we all know from having done this now for many, many years that the major objection to accepting treatment, the major objection is money. And some people get a little bit uncomfortable with it and can make comments like that and talk about all the work that they need. But I think that explanation is just very, very good. You know, the chairside assistant who the patient turns to when the doctor walks out after presenting the treatment, or the treatment coordinator or the financial coordinator said, and I've been to the dentist in my other city, and I came here, and my gosh, this is off the charts, no pun intended. And this is such an appropriate comment that there's a legal obligation for the dentist to present the treatment that's needed. They don't have to accept it.
Can you imagine, and this has happened, where the dentist, knowing the patient can't afford much, or that they don't have insurance, or whatever the reason might be, they don't go into a complete diagnosis. And for whatever reason, the patient goes to a new dentist and says, boy, your old dentist really screwed up. They missed this, and this. Mm-hmm. Now, all of a sudden, I think I might have a claim against them. Mm-hmm. And, technically, one could make a case that that's negligent if you're not appropriately diagnosing. So my advice to dentists is you do your job. The patient has no obligation to accept your recommendations. You have an obligation to make them.
It's very good. Chris, this is terrific.
Thank you.
It's very, it's almost too simple, because you hear what your mantra here. Your mantra is documentation. We could have some chanting. We could have a chant here, but it's and we've been here. I've heard this countless times. It's almost that it just becomes a cliche. But I've seen everything you're saying in lawsuits against doctors who ended up losing them because they had no evidence showing.
It's absolutely true, Allan. Absolutely true. There's case after case after case. Again, if we had more time, we could talk about some of them, that where a few simple documentation or chart notes would have prevented this from even going to court and resulted in a settlement of sometimes a big number.
Yeah.
And Sarah, this from working with dentists on staff, is if a dentist gets sued, they take it extraordinarily personal.
Yes.
And I mean, of course, anybody would. I shouldn't mean to say it the way I do. And so if we can give them just a few tidbits here and there to keep them out of court, I think they should take it. And like I said, I've been involved in hundreds, if not thousands, of claims where, had the dentist done things just a little more complete, it wouldn't have been an issue.
Gosh.
Great message, Chris.
Great
message. We're going to push this out. We're going to push this out to lots of doctors. Of course, we post these as a follow-up on LinkedIn and other social media. Chris, thank you so much for this. As I said, it's the simplest things are often the most powerful, and we hear them over and over again. But thank you for reiterating this really important message.
Well, you guys do a great job, Allan. I'm very happy to be part of your team or to help out wherever I can.
Thank you very much.
Greatly appreciated. And to Allan's point, we just hope that everybody gets a chance to tune in for more of our episodes that we have coming up. They're every other Tuesday at 11 o'clock Pacific or 2 p.m. Eastern. And we have, again, a really great lineup over the next few months. So definitely tune in. Chris, thank you again so much. Really appreciate it. It's always so much fun to see you. I can't wait to do lunch again soon. And yeah, we'll just keep in touch.
Always a pleasure. Nice. Thank you.
Yes, you're so welcome. Chris, if any people listening to this podcast would like to pick your brain or be in touch or utilize your bring you out of retirement or whatever, how do they contact you, Chris?
Well, Allan, Dennis gave me a good livelihood for a number of years. I'm happy to help any dentist anywhere if I can. I don't charge anything. You can call me or email me. I don't have it set up. I'll tell you my direct line or my cell phone is 503-708-6972. And my email address is C as in Christopher, F as in Frederick, Verbiest, VERBIEST @gmail.com. And Sarah, you have all my information, so you can post it if you want to.
We'll post it as part of the podcast as well when it goes up on LinkedIn. So, Chris,
do I have time for one more tidbit?
Of course, please go right ahead.
So one of the things we didn't get to today, and Sarah knows I can go on for hours, but when it comes to charting, please do not forget to do informed consent.
Yes.
Even in jurisdictions where it's not considered law, if you go into a courtroom in a lawsuit without informed consent, the judge will treat it as law. And so you have to inform the patient of the procedure, alternatives to the procedures, risks of the procedures, any questions they might have. And you can do it any way you want. You don't have to write a huge narrative. You can do it in just four little an acronym of 4 letters, PARQ. But you have to have something in there that says you went through this process. Or because, again, if it's not in the chart, it's presumed not done.
Right.
Very good. Great point.
Oh, that's a very good point. Thank you, Chris.
Thank you, Chris.
Too.
Pleasure. Anytime, you guys.
What a pleasure, Chris. Great to see you. Thank you so much.
You're very, very welcome. Thank you.
Thank you, Chris.
Thank you, everybody.